Welcome to Badm 107 lecture on capacity and legality. This is a make-up lecture so that we don't have to try to reschedule class time. Legality and capacity relate to the last two elements of contracts. We've looked at offer and acceptance, consideration and intention to create legal relations. With those four plus these two, then you will know you'll have a binding contract. So first we're going to look at capacity, and generally this is not a problem. Most contracts involved adults of full capacity. However, every once in a while there is a problem that crops up, and if you look at the slides, slide 98 lists 6 groups which are under a limited capacity to contract. That doesn't mean that they cannot contract. What that means is that they are limited in only some respect. Now, the first one on the list is minors, and here we're not talking about those people that dig in the ground. We're talking about minors, i.e. people that are considered to be children. And the rule is that contracts with minors are enforceable by them against the other side, but not necessarily by the other side against minors unless the contract is for necessities. All right, so let's first of all determine what a minor is. At common law, you were considered to be a minor until you were 21 years of age. I can remember when my sister turned 21, we had a big party for her. There was a cake with 21 candles. There was she got a necklace, a really beautiful necklace with 21 $1 bills stuck in it, and it was obviously a big deal for my parents. And I was thinking, well, you can vote when you're 18, you can drive when you're start learning to drive when you're 16. What's the big deal, right? Well, for my parents, back in those days, the common law dictated that you were an adult only when you reached the age 21. In the province of British Columbia, we have altered the common law with what's called the Age of Majority Act, and that specifies that you become an adult when you're 19. Now, this is provincial legislation, and so all the provinces have their own legislation, and unfortunately there's no consistency, although there is a rhythm to it. In BC, you are an adult and when you're 19, Alberta 18, Saskatchewan 19, Manitoba 18, Ontario 19, Quebec 18, Atlantic provinces, who knows, who cares? No, I'm only kidding. Each province has their own statute dictating when you become an adult. Just to the south of British Columbia, of course, there's the state of Washington, and in the state of Washington, you are still considered to be a minor until age 21. All right, so now we know what a minor is. Where does the law come from with respect to their capacity to contract? Most of it is common law, judge-made law, but it has been codified to a certain extent in the British Columbia by the Infants Act. So if I, as a minor, enter into a contract with you to buy, let's say you're London Drugs, and I buy 10 CDs at $20 each for $200, and I give you a check for that amount. I go home and then I decide, gee, these are nice, but they're not great, and gosh, I don't want to pay for them. Well, I can actually, as a minor, put a stop payment on that check. And London Drugs will not be able to either sue me for the money or ask for the return of the goods. It's one of the dangers you have as a business person dealing with minors for other than necessaries of life. What are the necessaries of life? Food, clothing, lodging, medical expenses, legal expenses, and transportation to and from work, I think, are the ones. Check with my slide to make sure that I covered them all. So we have the situation where this is the rule with respect to minors. My apologies for the short break there. I got interrupted by a family member. However, I'm back at it now. So the rule with respect to minors is that a minor is bound to a contract, but only for necessities, and that if it's non-necessaries of life, then they can not pay for that contract, and they can actually not have to return the goods. This came from a very old English case, Ryder versus Wombwell, where Wombwell was a son of a deceased baronet, so in the royalty in England, and bought some very expensive presents for some of his friends, gave the presents away, and then decided that maybe they weren't that close of friends or whatever, and decided not to pay for them. The jeweler and other merchants sued uh, the fellow, and the court said, if you deal with a minor for non-necessaries of life, then you have to take the risk that they may not pay for them and they don't have to return them. That brings us to the next item on slide 98, and that's beneficial contracts of service. Minors are also bound to these types of contracts, which are just, in fact, employment contracts. And the court's attitude here is that minors should learn a good work ethic, and so they should be bound to employment contracts. So if you started a job and asked for an advance on your salary, then quit, you would have to pay that advance back because you are bound to that contract and you can be sued. That's the world according to minors, and it causes a real twist for businesses nowadays because the Infants Act of British Columbia says that a parent cannot waive the rights of a minor, and this causes conniptions in um, businesses like ski hills and other extreme sports. Because you get children to sign a waiver, and of course the waiver is not enforceable against them because whatever activity they're, bungee jumping or something like that isn't a necessary of life, and so they're not bound to pay for those contracts. On the other side of the coin, if a parent signs a waiver on behalf of a minor and says, yes, you are protected against lawsuits from us if my child is injured, those are not valid because the Infants Act does say that parents and guardians cannot waive the rights of a minor. So I can sign a waiver for my children, and if they're injured, then my children have the right to sue anyway. Okay, so the risk management measure with respect to dealing with minors. You have to decide to either retain the risk and say that their market is so important to my business that I'm willing to assume that they will pay in most instances, and if they don't, then I'll just have to bite the bullet and realize I cannot collect that particular debt. So, or conversely, you say no minors allowed. And in contest promotions, where McDonald's, for example, has their monopoly contest on, they will say that in order to be valid, you have to be of the age of majority or over in the province, state, or country of domicile. So you win a burger, nobody cares. You give them the little game piece, and bingo, you get your burger. But if you were to win one of the substantial prizes, then you would have to prove that you're over the age of majority, and you have to answer a skill testing question, that sort of thing. So they take that into account when they're dealing with minors. That brings us to the slide. I want to back up just for a second and talk about Aboriginals and married women. Aboriginal peoples are native people are under limited capacity to contract if they're living on the reservation. So if they're living on a reservation and they enter into a contract with somebody off the reservation, that contract may or may not be enforceable depending upon the Indian Act. Well, everything's in a state of flux with our native people right now. They're getting self-government and they're becoming fully enfranchised. So this is not going to be a critical issue, and I don't plan to deal with it to any great extent. I'm just dealing with the 6 that are listed on slide 98. Married women, I believe it's now even been taken out of the textbook, but married women used to be in there as someone who is under a limited capacity to contract. You'll have to excuse us. That's the phone. 1 second here. Well, they're going to answer it upstairs, so let's not worry about it. If they're under a limited capacity to contract, or were, because they were considered to be very much attached to their husband. So much so that in 1820 they were considered to be chattels. And I read the Upper Canada Gazette, numerous places where a farmer would say, need cattle will trade wife, because the wife was considered to be a chattel, and you could trade your wife away for some good cattle, and then you could just send off to Britain and have another wife sent over to you. So the attitude towards women has changed over time, obviously, but it really wasn't until the early 1900s in Canada that it really came to a head. There was an appointment contemplated to the Senate, and it was going to be the first woman senator, and there was a question of whether or not under the Constitution Act a woman was actually considered to be a person. This was taken up by 5 women from Alberta who challenged this idea. Went to the Supreme Court of Canada, and in 1929 the Supreme Court of Canada determined that women were not persons. A bit surprising. The legislature got involved very quickly and changed that by passing laws, of course. And I bring this up really because we have to be a little tolerant of other countries and cultures, particularly the Middle East, where we think, gosh, the women are not treated well. Let's give them a little bit more time to determine where they want to go with respect to that, because it was only 100 years ago that women were suddenly considered persons in Canada, and 200 years ago they were considered chattels. So let's not be too hoity-toity. Anyway, I'm getting down off my soapbox there. That is not testable. I just wanted to comment on that. Turning to the next slide, which is slide 99. No, that's the 5 women, a picture of the article from the newspaper about the 5 women that challenged the concept that women were not considered to be persons. Slide 100 deals with the actual minors situation, and we've covered that. So now we go to slide 100, which lists the other groups or persons under limited capacity to contract. And, oops, lost my paper. Okay, let's look at it. Persons under a diminished capacity to contract. These are people that are under the influence of drugs or alcohol. And if you as a business person know the person that you're dealing with is intoxicated, that contract will be considered to be unenforceable, except for necessaries of life, just as with children. That doesn't come up very often, and so that's all we're going to say about it. The next one in the list, though, is a bit of a surprise, and that's corporations. Corporations are separate legal entities from their owners, and they're considered to be have all the capacities and rights of a natural person. So that means that they can enter into contracts, but they are under a limited ability in this respect. If I incorporated a corporation in the province of British Columbia to run a bank, and you know how I feel about banks, I hate them, but I'd like to be one and be able to make all those profits. Well, if I incorporated under the province of British Columbia and started a bank, it would be ultra vires the powers of my corporation to do banking. Ultra vires, remember where we saw that before? We saw it with respect to constitutional matters. It applies to corporations as well. It would be on the powers of my corporation to be a bank. Why? Because in order to run a bank, you have to incorporate under the Bank Act federally. Same thing with trust companies. That's provincial legislation, but you would have to incorporate under the Trust Companies Act. Credit unions under the Credit Union Act. If you wanted to run an airline, you have to incorporate under federal statute. If you want to run an insurance company, special statute. You want to run a railway, special statute. So in certain respects, corporations are limited in their capacity to contract by the statute that they are supposed to be incorporated under. Most often, corporations are incorporated under the laws of the province of British Columbia to do business, and no limit on their capacity to contract. The next group, a bit of a surprise again, labor unions. Labor unions at law do not exist. We have a labor relations code in the province of British Columbia that allows a labor union to sign contracts on behalf of its members, and that contract will be binding, even though the labor union isn't incorporated like a corporation is, and so does not really have a separate legal existence. It prevents the problem that, for example, at the university here, all the instructors are members of a union. Well, every one of us would have to sign the collective agreement, and that would be total chaos. So the union can sign on our behalf. Now, that causes some problems in the province of Ontario, for example, and this is in the book, textbook. There was a lady who was mistaken as a scab laborer about to cross a picket line and go to work, and the union, a very militant one, beat her up. And she sued the union to recover for her damages, and the court said, you cannot do that. The union does not exist. You have to sue somebody that exists. The lawyer for the elderly lady said, well, does that mean she doesn't have any rights here? And the court said, no, she's supposed to sue the people that were actually beating her up. Now you can see the problem here. She's being beaten up, and she's, what's your name? How do you spell that? Because I plan to sue you later. So again, it's an example of you have a legal right, but there's no justice here because there's no practical way in which you can enforce that. That's in Ontario. I don't think that has changed. However, in the province of British Columbia, there was a fellow by the name of Terrian who was a truck driver, and he started up a business of his own, got a contract with the city of Vancouver. He required some other truck drivers. I can't remember quite how many. I think something like 18 trucks to complete the contract. So he hired 17 truckers. Along comes the Teamsters. They have to be members of the union. And he said, yeah, sure, no problem. Sign them up. And they said, you too. And he said, no, I cannot be a member of the union. I'm the owner of the business, and if I'm a member of the union, the city will not deal with me. You gotta be a member too because you drive a truck. And so they forced him to become a member. He lost the contract, and all 17 or 18 of them were out of a job. So a bit short-sighted on the part of the union. Also, Terrian lost his business, so he sued the union. The union defended on the basis of, hey, you can't sue us, we don't exist. And the judge in British Columbia said, well, wait a minute, you have an office, so you've signed a lease, you rent equipment, so you signed rental agreements, and you're signing all these collective agreements on behalf of your members. So if you do those things, then you can't, on the other hand, say, wait a minute, but we don't exist. So you either exist for the purposes of being sued or suing, or you don't. You cannot have it both ways. So they found the Teamsters liable, and Terrian managed to recover his money. Busy place this morning. The phone went off again, so I just put it on hold until it was taken care of. All right, so we've dealt with labor unions. The next group on the list is enemy aliens, and as I mentioned earlier, these are not little green people that come down from space and say, lead me to your taker. Notice how I said, lead me to your taker. That's because the phrase was usually, take me to your leader, but now that we're so heavily taxed, it's lead me to your taker. Haha, joke. Anyway, enemy aliens are people that are from a country that Canada is at war with, and I suspect that right now it's limited to the Taliban or ISIS, although I'm not sure that we've actually declared war on them. It might just be a policing action. But if a Taliban business person had a contract with a Canadian company, they're going to pay us, we're going to send them guns. Number one, it would be illegal. We'll come to that in the next element of a binding contract. But number two, they would not be able to sue had they paid us and we did not ship them the guns because they have no standing in court. They lack the capacity. The last one is bankrupt debtors. When you go bankrupt, all your assets are transferred to a receiver who then sells what he can and divides up the money amongst the rightful creditors. While you are in bankruptcy, and you can eventually petition to get out of bankruptcy, but while you're in bankruptcy, you don't have the luxury of getting a loan to buy a car or going on a trip to Disneyland or taking a cruise. Those are non-necessaries of life, and only contracts with respect to necessaries of life will be enforceable against the bankrupt debtor. So if you're a car dealer and you do not do a check at the bankruptcy registry before giving someone a loan to buy a car, then it may turn out that that contract will be set aside because one of the binding elements is missing, and you'll get a used car back, and all the money that has been paid to you by the bankrupt debtor goes back to the receiver and is divided up amongst the rightful creditors. So those are the groups under a limited capacity to contract. And with a list of 6 like that, you've got to think that maybe that's a Part B exam question. List 5 of the 6 groups or persons are under a limited capacity to contract. That brings us to the slide 10 on legality. Now, legality is something that we're going to go into very superficially with respect to most aspects. But when we get into restrictive covenants, I'm going to cover that in the next lecture, and that will be examinable and will almost certainly be on the exam in some way. Well, what we're talking about here with respect to legality of object is we're not dealing with hit contracts or contracts for the sale of drugs or stuff like that, because automatically those things are not enforceable in the courts of law, and would not be, and you'd not be held binding to those contracts except by, Guido, shoot you in your knee if you don't pay for your drugs. But what we're talking about is business situations where business people try to contract and don't realize that they're actually doing something which is not allowed. So contracts can either be illegal or they can be void. And there's a slight difference. Illegal contracts, for example, the courts will not enforce the contracts, and they will quite often express their positive disapproval. I like that phrase, positive disapproval. It means you're going to be fined and or imprisoned. So those are contracts where, for example, 2 businesses get together and they agree to, I'll deliver the product in BC, you deliver in Alberta, I won't go in Alberta, you won't come in BC, and that way we'll be able to keep the price up and we'll both get richer, and it'll only be the consumers that, that get shorn as sheep. Those would be considered to be conspiracy to lessen competition. The businesses may not even know that or think that this is an illegal contract, but the courts will, if it find out about it, not enforce that, not allow one party to enforce that contract against the other, and they'll express their positive disapproval by fining you for conspiracy to lessen competition. So that's the illegal side. On the void side, less stigma attached to this, and there are some slides in there which help us understand this. One of the situations would be if you were an employee of one company and I'm the owner of another company, and I come to you and I say, I will pay you more money if you come and work for me. And you go, okay, so you quit at the other company without giving them any notice, which is against the law, and you come and work for me, then I'm in a very dangerous position because I can be sued by that other business for inducing you to breach your contract with your previous employer. And that's a tort, and we're going to get into that in Chapter 3 following this one. But also, now I have a contract with you, and you don't perform or you do something wrong, and I say, well, I'm going to I'm going to sue you, and we get into court, and the judge says, well, wait a minute, no, that contract that you have with that employee is void because you caused this tortious action to make him breach his contract. So it's void, and gosh, I don't have to, or I cannot go after you. So that's one example, and that would be void at common law because it's a contractual issue. Now, contract void at statute, the good example that we use is you come to me and you say, hi, hire me as your employee. And I go, well, our business isn't at the point yet where I can actually afford to hire another employee. But, please, I really need a job. I've got a mortgage. I got house payments. My kids need braces. And so I go, well, look, if you pay your own UIC and CPP and if you pay your own WCB, then yeah, I can't afford to hire you. So we're very careful people. We draft up a contract. You begin to work for me. A few months later, one of my employees gets hurt. Which one? You. Okay. So it turns out that you didn't pay the payments to WCB, and so you have no benefits. WorkSafe BC comes and they go, okay, what's going on here? We got this person, he's injured, we want to retrain him, we want to pay for his rehabilitation, but no payments were made. I show them my contract and I say, well, I had an agreement with him that he had to pay his own WCB. A section in the WCB Act or Workers' Compensation Act says that an employer cannot contract out from under the statutory provision where the employer is responsible to pay. So the courts have a problem here. If they said, well, that contract is void, that would mean at law that we're supposed to be put back into the position we were in before the contract came into existence to the best of the court's ability. Which means all the wages that I've paid to you, you would have to pay back to me. And you worked for me for 3 months, so I'm supposed to give you 3 months of time back. Well, we don't have time travel yet, so we cannot do that. So that it would be unjust if the court said, well, it's void. Pay back all the money, but you don't get anything, Mr. Employee. So what they do is they don't say the contract as a whole is void. They say the provision in the contract to contract out from under the Workers' Compensation Act is void. So that means I should have been paying WCB for you. So I'll have to pay all the WCB that I haven't paid. I'll have to pay a penalty, and I'll have to pay interest on the money that I haven't paid. I have to do that, and then the employee is covered by the WCB and will get rehabilitation and retraining if necessary. So the contract was not void as a whole, but the provision was void. So that's the void contract idea. So in the scheme of things, we we realize that there are illegal contracts and void contracts that come into play, but not very often. So that concludes the portion of the chapter on capacity and illegality of object, with the exception of restrictive covenants. Now, restrictive covenants fall into that category of contracts that would be void at common law. And we'll get into it next class, but a restrictive covenant is a provision in a contract which seems to lessen competition, and the courts don't like that, and they hold them void, and that would cause a problem for a lot of businesses, particularly in purchase and sale of businesses and employer and employee contracts. So thank you very much, and I will see you in class next time.